Today I'm with Ronnie Solomon. It's a pleasure to meet you, Ronnie. Would you mind introducing yourself?
Sure. It's a pleasure to be here. Thank you for having me. Again, my name is Ronnie Solomon. I'm an attorney in the Federal Trade Commission's Bureau of Consumer Protection within the Division of Privacy and Identity Protection. And as the name suggests, my work focuses on litigation, investigations, and policy relating to data privacy and data security.
And you are very involved in the GoodRx case, which is making waves everywhere these days. So I would love to hear about it from you. Can you start by telling us about the GoodRx business model and what services they provide?
Yeah, sure. So GoodRx is a really popular mobile app and website. They advertise that they offer consumers the ability to save money on prescription drugs. You download a GoodRx coupon and show it at the pharmacy and can attain a lower price as they advertise. They also offer a telehealth platform. Previously, it was called Hey Doctor. Now it's known as GoodRx Care, where you can get virtual medical care from a licensed health professional. GoodRx is largely not covered by HIPAA. So it is a direct-to-consumer healthcare company that does not have to comply with HIPAA regulations, the HIPAA privacy or security rule in many respects.
Yeah, awesome. Thank you. So what went wrong? Can you tell us about the case and the FTC's allegations here?
Yeah, sure. So what the FTC alleged was that GoodRx for several years was sharing really sensitive health information, details like the names of medications that their users had actually purchased or redeemed at the pharmacy, things like dosage, quantity, the name of the medication, associated health conditions, in some cases when users were seeking treatment for certain health conditions. GoodRx was sharing that information with third-party advertising platforms like Facebook and Google and others that we name in our complaint. This was in violation of explicit privacy promises that GoodRx had made. But not only was it sharing the information, it actually was using that information to target users with advertisements on Facebook and Instagram. So once that health information, which was, by the way, personally identifiable, once it was shared with Facebook, for example, GoodRx went to their part of the platform, re-identified users, linked them up to their health information, and then actually placed their users into category-based custom audiences, right? So users who might have HIV or take a certain medication, GoodRx grouped those audiences, those individuals into audiences and target them with health and medication-specific ads. So our complaint alleged a number of things. We alleged first deception. This was a violation of our prohibition on deceptive practices. And again, it was GoodRx made a number of explicit privacy promises that this violated. Second, we alleged that these practices were unfair. Again, a violation of Section 5. In particular, we alleged not only that GoodRx was sharing this information in violation of its promises, but the company, we allege, actually had no policies, procedures, compliance programs sufficient to actually prevent this unauthorized disclosure of health information. And so we allege that that failure was an unfair business practice that was harmful to consumers. Sticking with unfairness, we also allege that GoodRx's failure to get affirmative express consent before sharing health information for advertising was, again, another unfair practice that was harmful to consumers. And then finally, we alleged that GoodRx violated our health breach notification rule, which requires covered entities like GoodRx to notify the FTC, consumers, some cases the media, when there's been an unauthorized disclosure of health information. GoodRx's practices first came to light in March of 2020 through a Consumer Reports article, but GoodRx failed, never actually complied with the rule, and so we alleged that failure and fined GoodRx a civil penalty of $1.5 million for that failure to notify. So I would encourage everyone to read the complaint. It's very detailed. We went into sort of a lot of detail of what the practices were that violated the law.
Thank you for breaking that down. The case ended up ending in a settlement. So can you tell us about the settlement in addition to the fine?
Sure. So in addition to the $1.5 million civil penalty, we secured really strong and in some cases groundbreaking injunctive relief that was really aimed at preventing these kinds of practices in the future. And so I'll highlight some of the more prominent parts of the order, which is now final, by the way. The judge has officially signed off on it. First, GoodRx is permanently banned from ever sharing health information for advertising purposes again. Second, it's in the event that it shares health information for any non-advertising purpose with third parties, it has to get consumers' affirmative express consent. And the order lays out in great detail the ways in which GoodRx has to do that. Third, GoodRx under the settlement is required to seek deletion of the data that it illegally shared with companies like Facebook and Google. It also has to implement a very detailed internal privacy program that has really strong safeguards to protect consumer data in the future. It has to comply with the health breach notification rule in the future in the event of any further unauthorized disclosures. And it is subject to ongoing audits by an independent assessor to make sure that its privacy program is actually complying with the requirements of the order. One other thing to note is that the order imposes data retention limits on GoodRx. So it requires GoodRx to have a policy with respect to how long it retains data, to post that retention schedule publicly for consumers to see, and also to outline the categories of information that it collects and the reasons for its collection of that information.
Got it. And you've mentioned this rule now, I think twice, the health breach notification rule. This case was the first time that the FTC took enforcement action under this rule. Can you tell us more about it and who's covered under the rule?
Sure. You're right. This was the first time we enforced the health breach notification rule. Essentially, this is a notification rule that applies only to non-HIPAA covered entities. So there is an analogous rule that HHS enforces with respect to HIPAA covered entities. But essentially, it requires vendors of personal health records and related entities. And the rule goes into what that means, but essentially, it involves electronic records of personally identifiable health information that is capable of being drawn from multiple sources and that is managed, controlled, or maintained primarily for the individual. And I would encourage everyone to go ahead and take a look at the exact language on our website at ftc.gov. But it requires that covered entities, when there's been any unauthorized disclosure of health information, have to notify the affected consumers, the FTC, and in the cases of a breach that involves more than 500 consumers, the media. And there are really specific and detailed requirements as to when and how companies can notify the required entities. And again, it comes down to, in some cases, whether or not 500 or more consumers have been affected by the breach. I'll also point out that in 2021, the Commission issued a policy statement setting forth in greater detail how we are going to enforce this rule. So a couple things to highlight there. First, the Commission has said that most direct-to-consumer mobile health apps and connected devices and the like are covered by this rule, and so need to comply with it. And second, it is worth noting that the Commission has said, and as the GoodRx action makes clear, this rule does not only come into play when we're talking about traditional cyber attacks and breaches. Anytime there is an unauthorized disclosure of health information. So here, in the case of GoodRx, GoodRx was voluntarily sharing this data with Google and Facebook. That is a covered breach. That is an unauthorized. That could be an unauthorized disclosure, and companies need to comply with the rule where that takes place. And finally, as we mentioned in GoodRx, we obtained a civil penalty. This is the first time we've done so, but companies should take note that they could be, if they do violate the rule, they could be liable for upwards of $46,000 per day for violating the rule.
Very helpful breakdown. Thank you. And finally, what should industry take away from this settlement?
Yeah, so I mean, I think the biggest takeaway here is that health information is really sensitive, and its unauthorized disclosure can lead to a lot of harmful consequences for consumers. And so digital health companies should pay attention to the GoodRx action, especially when we talk about the direct-to-consumer apps and websites that are not covered by HIPAA. I think the GoodRx action makes clear to the industry, sends a really strong message that the FTC is going to really vigorously enforce the law in this space. So some of the key takeaways, as I mentioned a lot, pay attention to whether or not you're covered by the health breach notification rule. Second, truthfully disclose your data sharing policies, and where you use, in particular, sensitive, personal, identifiable health information for advertising, you should get affirmative express consent. That was something GoodRx didn't do, and why we brought an unfairness count. Third, it's really important for companies to have, maintain, and enforce policies and programs to prevent the unauthorized disclosure of personal information, especially health information, and to make sure you're actually doing something to meet your privacy promises to consumers. Again, GoodRx didn't do that, and that's another reason we brought an unfairness count. Fourth, ensure that you're vetting and all of your third-party data flows, right? Make sure you understand and know who you're sharing data with, what specific data is being shared, and how it's being shared. This is really important because nowadays there are so many plug-and-play automated tracking pixels and ad tech tools that app publishers can sort of just integrate into their website. Our complaint talks a lot about the Facebook Meta Pixel. Companies might use this to send information to Meta or any other company for targeted ads, for analytics. But the danger here is that if you don't integrate them properly, you could be inadvertently or intentionally, as in the case of GoodRx, sharing sensitive health information with third parties to whom you don't intend to share. And so companies really need to be aware of the significant legal risks associated with these tools. Finally, if there has been any unauthorized disclosure of health information that is covered by the rule, comply with the rule. Notify consumers, the FTC, again, in some cases, the media, and sort of go through what the rule requires in terms of notice obligations. Some other best practices, collect only the data that you need and delete it when it's no longer necessary. Limit data access to only those employees that actually need access. In addition, it's a best practice to make sure you have in place contracts or service provider agreements with third parties with whom you share data that contractually limit how those providers can use, share, sell, exploit consumers' data. In the case of a service provider agreement, those agreements would limit third parties that receive consumer data to only using that information to provide the service back to the company and not share, sell, or exploit it in any way. So those are some things that companies in the digital health space can take note of and be aware of. And again, I would encourage everyone to read our complaint and to check out the resources that we have available at ftc.gov, our health data privacy page, our health breach notification rule portal. We also have a mobile health app tool that allows the user to actually go through a series of questions, and it helps guide you and tell you which laws might apply to your business, your product. We've developed this in coordination with HHS and ONC. And so it's a really helpful resource that I just want to make sure everyone is aware of.
Oh yeah, really appreciate those resources and the takeaways and your time on this case and your time with us today. So thank you so much, Ronnie.
Thank you so much for having me. It's been great.
My pleasure.